Welcome to All Things Financial with Jack Driscoll. Each week, Jack takes on all things you thought were hard to understand about your finances and makes it fun, easy, but most of all interesting. From insurance to the best way to save your money and squeeze the most out of the dollars you put aside for your rainy day. And now, you have a friend in the money business. Here's your host, Jack Driscoll.
Welcome back again, everyone, to another edition of All Things Financial. What we're trying to do in the show, as I've mentioned in the past, is bring out information that we as financial planners deal with on a daily basis, but most consumers deal with never, or maybe once in a lifetime. You know, we'll get a situation where someone's buying a house, and you'll shop for a house and you'll go through all that effort, and then after you buy the house, you're done. And for the next 30 years, you don't have that experience. Where a realtor continues that experience over and over again, and some get quite good at it. It's the same in financial planning. You only get the chance to retire once, but a financial planner might have retired people for 40 years or 30 years, done thousands of retirements. And it's that type of an experience that I wanted to bring out some information and share so that some of you that are watching and listening on the radio can benefit from. Maybe other people's experiences, good and bad, so you don't make the same mistakes that other people have made. And did you do repeat the same successful strategies that other people have done? Well, last week what I did was I touched on beneficiary reviews, and I want to continue a little bit there because I asked many of you to go check your beneficiaries on your 401ks, your IRAs, your annuities, your life insurance, and your will. And I mentioned that I think you'll find, if I'm right, they don't match. And they should match by most people's expectations, but they don't. And the reason is, and it's a flaw, is that they're not being reviewed periodically or properly enough. And even on the pension at work, you know, when you go to work for a company, you sign up for benefits and you sign up for employment. And many times at that point, when you're signing up for a job, you may not even be married. You're young. And later, after you get married, nobody's there to remind you, name a beneficiary on your pension. And you say, well, what's the difference? I have plenty of time until I have to do that. And the reality is, you're right. But since it never occurs to you that if you have employment 20 years history, you may be partially vested in that pension already. You have no intention of retiring, nor could you receive that pension until you were 59 or 55 or 65 or after 30 years or whatever the pension documents specify. And then you die in a car accident. And lo and behold, it turns out there's a partial survivor benefit on a pension if, and only if, a spouse is listed on as a beneficiary. So if that is the case, and here the neglect to name a spouse as a beneficiary causes a problem, there may be no survivor benefit. Some pensions have an automatic default that if a spouse exists at the time of the death of an owner, that the beneficiary will receive some payout. Other pensions specify pensions are for the life of the employee only. And unless the employee in advance chooses any survivorship options, it's a life-only pension. So that's why I implore all of you to exercise what I instructed last week, pull out all your forms, and I hope some of you did. Well, this goes on a little bit further, and I wanted to talk about it and expand upon it because I'm getting questions on this beneficiary review process. What do we look for? What do we do? So here's some mistakes that I see, and in today's show, I'll go over some steps to follow. Number one, you get married, you don't have a will. Number two, you get married and now have a child. You don't have a will. Number three, you get married, have a child, and now buy a house. You don't have a will. Here's the problem, folks. You don't have a will. So I'm a financial planner. I do not do anything legal. I provide no legal advice. The extent of my discussions in any area of legality are contact an attorney, go find an attorney, go hire an attorney. That's the farthest it gets. But for a financial planner to be effective, we have to help you recognize areas in your lives that can impact your financial decisions by not having the proper legal documents in place. And the primary legal document that we first have to ask is, do you have a will? You'll say, what does that have to do with finances? Okay, let me give you an example. You don't have a will. You do have a 1-year-old son. You and your spouse die in a car accident. With no will, there's a fight on guardianship over the child. Who's going to take care of the child? Oh, obviously my mom, my dad, my sister. Hey, it's not been determined in advance. Nobody has filed for guardianship. Nobody has a will. Nobody has a power of attorney before death. Nobody has anything. There's no executor even named or executrix named on the estate of your choice because you didn't have a will to prescribe who would be the executor or executrix to administer that will. It's a mess, folks. It's just a mess. So how does that affect financial planning? Well, obviously in a major way. Where's the money going? Now, if we have financial documents drafted, IRAs, life insurance, annuities with beneficiary designations, it brings up an important question. Because if you look into this, you'll say, why do I need a will if I have beneficiaries listed on my pension, my 401k, my life insurance, my annuities, and my IRAs? And it's a good question because I, as a financial planner, might ask, is that all that you have? And let's pretend the answer is yes. You say, these are all the assets that I have. Well, it's interesting because if you did go out and get a will, which I still am going to advise you to do, it's true, the will not, in most cases, have any power over those financial documents that have beneficiary designations. So let's talk about that for a minute. Even if you had a will and it said, I want everything to go to my uncle, but all your beneficiary forms on your IRA, your 401ks, your pensions, your life insurance, and your annuities say otherwise, each of those financial instruments will follow its own beneficiary designations, regardless of what is listed on either any of the other financial instruments or the will. None have power over the financial instrument itself with the named beneficiaries. So if you have 5 different life insurance, IRAs, annuities, 401ks, pensions, etc., all the beneficiaries are different. A will won't fix that. A will won't even affect those. When someone passes away, the annuitant on annuities, the insured on life insurance, the owner on IRAs, the beneficiary payouts are made by the company directly to the primary beneficiary or beneficiaries named on those accounts. Period. And that is done not through the process of probate. So all of those financial instruments I just mentioned typically avoid the process of probate if they have beneficiary designations where the money's going to be made directly to beneficiary. How does that affect financial planning? Folks, that can mess up your financial plan entirely because take this situation where you have beneficiary designations and then you have children. No one thinks to tell you, change all your beneficiary designations now, update them all, because you now have a child or children. And prior to having children, you may have had different beneficiary designations. Each spouse might have had their own parents be the contingent beneficiary. So what I mean by contingent is all beneficiary designation forms normally ask, list who you want your primary beneficiary to be. So if you're single, you may list your parents. If you're married, you may list your spouse. What if you were single, listed your parents, and then got married and never changed them? Now you're married, you have a house, you have financial obligations, you pass away, you forgot, your spouse does not inherit because you forgot to update the beneficiary designations and your parents do. But lo and behold, it's worse because your parents, there's only one parent surviving, and that parent's in a nursing home. You have just put or left a beneficiary designation to a parent who's in a nursing home, who had qualified for Medicaid possibly. And in this case, now you've basically willed the money or left by beneficiary the money to a nursing home. And here your spouse still has the mortgage to pay off. And with no financial assistance to pay it off. Why? Because of a simple error you didn't update. No one told you, it's not your fault. But you were never told or thought to update your beneficiaries periodically from time to time as circumstances change. So there's number one risk. Number two risk, spouse's primary beneficiary. Congratulations, you updated your beneficiary list. And now, later have a child, you still have the spouse's primary beneficiary. You both die in a car accident, and boom, you still have a major problem because there's no contingent beneficiary listed. So back to my discussion, contingent versus primary. Primary beneficiary is the first in line. That can be one person or a number of persons. So a primary beneficiary can be my 3 children. Do you see what I mean? If I'm divorced, if I'm single, I can say, or a single parent, I can say my child or my children are my primary beneficiaries. If I'm married, I might say my spouse is my primary. Well, the contingent beneficiaries should be filled out on every one of those forms that I asked you to look into last week. There should never, in my opinion, be just a primary beneficiary. So there should be a contingent beneficiary or beneficiaries listed. You run into this situation, you say, I have primary beneficiary or beneficiaries taken care of. It's all my sisters and brothers or whatever it is. And then you have contingent, that if any of the primary beneficiaries had predeceased me, where does their share go? If I only have one primary beneficiary, my spouse, where does the whole amount of the money go? And it might be down to my 3 children or whatever. If you don't list the contingent beneficiaries, it's very unlikely it's going to get to the 3 children. Okay, now let's talk about the next issue. I just made minor children a beneficiary. Uh-oh. And this is why I say get to the attorneys. So you go to the financial advisors, and I'm saying again, I can't stress enough, not a financial advisor. Get 2 certified financial planners, interview a lot of them. There are good ones and bad ones, but at least it's evidence of some higher level of learning that might help get to an experience level that can help you with all of these different areas. But we go and you buy your life insurance with a life insurance agent. You buy the annuities from an insurance agent. You get the 401ks through the 401k administrators, and you get your mutual fund IRAs through a financial planner or a stockbroker. All of these are not placing very great importance on your beneficiary designation when you get to that spot on your account applications. So they list the parent, the spouse, and the children. So sometimes on a contingent beneficiary form, we'll see children of the insured, or on your will. We'll get back to a will, we'll get back to the beneficiary form, and we'll see either the words children, or we'll see the name of the children. There's kind of a big difference. If it says children, it might or might not include by law stepchildren, previous children, current children, adopted children, who knows? So every time I have these beneficiary designation discussions, I keep repeating, don't let the insurance agent or the financial planner like myself choose or help you choose your beneficiary designations. We're not qualified. We can help you identify potential problems. Your attorneys should be the ones helping you make the choices of who and how all your beneficiary designations and your heirs on your wills should be listed. I'll bet you never heard that before. I've got almost 40 years in the business. Don't you think I'd be qualified by now? I'm only qualified at this point in my career to recognize that I'm no way near qualified to help anyone choose beneficiary designations, because that is an area of law. And you can see the legalities and the legal complications of making errors in your beneficiary designations. My highest skill is helping you identify correcting mistakes or preventing mistakes. This is a big one, folks. So these beneficiary designations or your will, you go through and you make on beneficiaries, my child, a 1-year-old. I told you had a 1-year-old son in this example. Hey, folks, have you asked anyone in your family, if anything happens to me, will you take the responsibility of raising my child? Have you asked? I know you're scared to ask. It's hard to ask. Who are you going to trust? There's no one as good as you are to raise your child. We know that. It's very clear. But if you both were not available because you passed away or were killed in a car accident, at least you ought to be the ones making the choice of who's the best option of the survivors, don't you think? If you don't make these elections in advance, maybe the courts or maybe a family fight will decide. And that's totally unnecessary. So you get to the attorneys and you ask them the questions. If we both pass away, yes, I have my child listed on my will, and because the attorney told you how to list them on all your beneficiary designations. But then you ask the attorney, but what really happens? All that did was distribute the money to them. No minor can have money in their account anyway, in their own name. So we have a problem just right out of the gate. How does the insurance company or the will or the courts even administer getting the money to the 1-year-old? We have a mess on our hands to begin with. So let's take, for example, one of your sisters is the one that you choose that would be best suited to raise your child if neither of you were available. So you ask your sister says, okay. You go to the attorney and you say, how do we make sure they're documented so there's no family fight? And they tell you, probably establishing guardianship. I don't really know. That's the legal side of this. So let's say they establish who's going to take care of your 1-year-old son and raise them. Well, now we have an issue. Do we want to place the financial burden on that same person? Or do we want to help them with the finances where we're actually giving them or equipping them financially with the resources to help raise your child and get them through college without putting the burden on this kind sister? So we list the child, or do we list the sister as beneficiary? So you ask the attorney and you find out, and the attorney helps guide you. And the attorney might say things like this. And these are better to find out in advance than later, by the way. The attorney might say, well, I don't know if you list the child, and you can list just children in case you have any children in the future. Oops, didn't think about that. So maybe we don't want to list the one child, the attorney might say, because are you still going to have children? Yes, we think we might try to have 2 more, or 3 more, or 1 more, or whatever. Well, we might not want to just list the name of this child. We might want to say any children. Okay, good point. So the attorney helps guide you through that, whether it says child or children or whatever. We now have a sister that we know we want to raise and has agreed to raise our children should anything happen to us. So they do the documents to enable that too. And picture this. All the money goes to the child, because the attorney might say, no, we're not giving all the money to the sister, we're giving it all to the child. Or should we give it to the sister? Well, that's another discussion. But then we give it to the child and we say, wait a minute, the sister is the guardian, and maybe we've enabled as the power of attorney over the child or whatever they do until the child's age of majority and can act on their own, which is age 18 in Pennsylvania. So who controls the money anyway? It's probably the sister. So we say, now wait a minute, do they have an account in their name? What if the sister dies? Does the husband of the sister now inherit my child's money? Oh, I never thought of that. What if the sister is in a car accident and there's a lawsuit for millions of dollars then claims against all of their assets and they have to file bankruptcy to protect their house and all of this money goes up in smoke due to a lawsuit? Oops, never saw that one coming. What if they get divorced? Oh my goodness, half of my money. So the attorney might say, hey, we better set this aside and establish a trust in advance for the child or children. Do you see how complicated this gets, folks? That's why I bring out the show. I'm bringing out the show for those of you who are interested in finding out how to prevent problems that others are going through because no one told them about these things. Some of you will listen and act on this. Some of you will dismiss it and change the channel. That's okay. But my value and obligation is to share with those of you who are interested. I don't want that happening to me. What happened to the neighbor down the street? Oh, what a shame. Oh boy, what a shame. No, most of this is preventable with skilled expertise in your corner on your team, helping guide you make good decisions in advance, can help prevent your family from incurring a lot of heartbreak that was, yes, avoidable. With proper advice, avoidable. I've seen 401ks and I've looked at the paperwork. You know what? If you look on that paperwork that I asked you to pull out last week and look at the beneficiary designations, I'll bet you'll see somewhere on that form a statement that says something like this. If you get married, all these beneficiary designations will become null and void. Whoa. Or if you become remarried, you say, what? So I have beneficiaries, I have the 3 kids. Hey, folks, there are laws in place, especially on 401ks, that you can't exclude a spouse, even if the spouse didn't exist when you did the forms and you never changed them. So let's say you had a spouse on there, you're separated, you changed your beneficiary to your 3 kids or left at your 3 kids, and then something happens to you. You think that's going to your 3 kids? Not unless your spouse or ex-spouse or however it works, separated spouse signed off on it, allowing it. No, it isn't. So get to the attorneys, folks. This is the continuation of my message from last week. What should it be titled? Get to your attorneys. All dealing with financial instruments and financial planning, yes. But all the mistakes that are being made are most likely preventable. All right, folks, that's another edition of All Things Financial. I will be back again next week, and thanks for tuning in.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.